me, before I got into this field, I didn't think much of it, but I thought maybe 40% would be a good number. But feel free to put it in the chat. I want to really know what the general public thinks in terms of what percentage are illegal. And I will go ahead and reveal the real number.
Brother Mirza, Saad, just a quick second, because some people are not able to see the slides. I don't know why. Who's not able to see the slide? Can you raise your hand, please? Mahmoud, Neil. Okay. Okay, it seems like everybody not able to. Can you stop sharing and reshare? I can see it. I don't know why some other folks are not able to see it. So maybe don't sync it with Microsoft Teams. Just share it in a normal way.
Yeah, it could be an issue between business Microsoft Teams and personal Microsoft.
I see. Okay, hang on. Let's see if I can do this. And present. Okay. Give me 1 second.
Okay, does everybody see the screen now? I can see it. No?
No, it still says.
Okay, I think I lost it too now.
Oh, there it is.
Yeah, now we can see it, but yeah, we can see your back. Your
yeah, it's working for me now.
Okay, hang on. Sorry, 1 second. Let me try and put this over here. Let's see if this works. Are you guys able to see the PowerPoint?
Yeah.
It's working for me.
Just make it bigger, please. Yeah.
Just slideshow maybe.
I can see the part of this. If you've started presenting, I can see the slide in your next slide. The screen that has your slide in the next slide.
Okay, hold on. Let me see how I can remove that.
This is the best way to
yeah, you just have to select the right screen.
Experience your tech abilities, brother Saad.
Okay, hang on. Are you guys able to see what's able to see?
We see the slide, the main slide, but then you see the next slide as well. The screen that has both the next slide and the main slide.
We're seeing the presenter slide.
Yeah. So you don't need to put it in.
If you have two screens, you probably need to share the other screen.
Okay. Are you guys able to see the other screen now?
Exactly. It's working well now. Yeah.
Lovely. Okay, and I'm just going to
five people telling Brother Saad what to do is like how many consultants does it take to share a presentation? Huh? That's an inside joke in IT, Saad.
I figured. I should
have done this for you immediately.
Okay.
Okay. You may want to go back to that slide with a question.
Okay. Yes. Let's go ahead and. So, what percentage of employment contracts in the workforce are illegal? So either 25%, 40%, 95%, 5%, or 50%. And again, before I became an employment lawyer, I didn't know this, but the answer is C. 95% of employment contracts that are out there in the workforce today are illegal. They do not meet any sort of ESA standards, and there's a reason for that. And we'll talk about the reason very shortly, but it has to do with judge-made law, or what we call the common law. And the common law is the legal system that is applicable here in North America and also in the UK and all other Commonwealth countries. Right, so the key employment laws protecting workers in Ontario are the Employment Standards Act, which sets the minimum standards. So, it'll set how much you can get paid, what termination clauses are there in your agreements, and what kind of leaves you can take. So it sets the minimum standards for employees. But, employers can actually pay a little bit more than the minimum standards, but anything that violates this minimum standards would be illegal. And that's why I presented the question earlier about how many clauses or how many contracts are illegal, because clauses set around wages, hours, overtime, benefits, leaves, termination, and severance pay, they're very tricky to actually navigate around. So that's why most of them are illegal. And then we have the Ontario Human Rights Code, which just protects us from being discriminated against. It protects employees from discrimination based on characteristics such as race, gender, age, disability, and sexual orientation. If you ever feel like there is any sort of if you're ever experiencing any sort of human rights issue or workplace discrimination or harassment, you can always file a complaint with the Ontario Human Rights Tribunal, or depending on which province you are in. Every province has their own tribunal. The next piece of legislation we want to talk about is the Occupational Health and Safety Act, or OSA. It ensures that you have the right to be safe and healthy at your workplace. So it includes protections against workplace hazards and provides you and I with the right to refuse unsafe work and without the fear of retaliation. So say if you are going to work and, if your employer asks you, you're an accountant or an IT person, your employer is asking you to, solder some wires when it's not really in your role and you haven't been trained about it, then that you have the right to refuse that sort of work. The next act that we want to talk about is the Workplace Safety and Insurance Act. This provides compensation and provides the framework of how we can adjudicate matters, so how we want to push complaints for workplace injuries, and it provides compensation for people who have gotten sick at work because of their working conditions. Think about being exposed to chemicals in an industrial setting, or they've been injured at work. Think about even sitting at a home office. Yes, sitting at a home office, if your chair is not right and they're demanding 8 hours out of you and you end up hurting your back, you end up slipping a disc, that is covered under this. And there are actually new safety precautions under the law that protect people at home, because now home is the new work environment since COVID. And then the Employment Insurance Act, it provides the financial setup for how financial support is to be distributed when you are unemployed, on maternity leave, or illness. And we're going to talk about a few more scenarios that are applicable here in Canada, and they might not be applicable in the States. But this is one huge advantage the Canadian legal job market has over the American one. And finally, what we want to talk about is common law protections. This is judge-made law. So imagine, I sue an employer as an employee, and we make a precedent-setting case. Now the case says, okay, this sort of clause cannot be, in the employee's best favor. So if any employment contracts have this, it is unconscionable and illegal. These type of cases are pumped out every year. Every year there's a new case that comes out that invalidates almost every single employment contract that is out in the market. And that's why I said 95% of them are illegal, because every year there's something that's out there that protects employees. It's always heading into the direction of protecting employees. So we want employees to know that the law is on your side at all times. And it is shifting only in that direction here on out. Okay. And then in Canada specifically, there are two separate jurisdictional scopes. There's a federally regulated employment, and then there's a provincially regulated employment. Federally regulated employment, it covers banking, telecommunications, interprovincial transportation. So if you're an institutional banking employee, meaning you're working in hedge funds and you're working in investments, then you are considered federally regulated. If you're working for a company like Rogers over here in the States, your comparison would be, a company like AT&T or Verizon. That is federally regulated. So it covers, jobs all across the nation. And then interprovincial transportation. So if you're traveling to different provinces in long hauls, or if you're traveling down south to our neighbors down south, you as a truck driver, you would be governed by the federal regulation, which is the Canada Labor Code. In addition to that, the Canada Labor Code also caters to the First Nations, uranium mining, and federally crowned corporations. Approximately 8% of workers fall under this jurisdiction. Provincially regulated employment covers 92% of Canadian workers. Now, I did talk about banking earlier, and I did talk about interprovincial transportation. Banking, if you're a retail banking employee, meaning you're at the banking branch, you're actually considered to be provincially regulated, not federally regulated, which is a very important distinction. And most employers use this misconception to scare employees from asserting their rights. And also the same thing goes for transportation, right? So not every single sort of truck driver is considered to be a federally regulated employee here in Canada. They would most likely be considered provincial if they are just driving within the province. So,
Brother Thad, sorry to interrupt here. Are you going to explain this further in next slides, or do you want to maybe again explain the difference between provincial and like the banking example specifically?
Right. I think it's a very small distinction because again, 93% of the employment is applicable is applicable under the provincial regulations. I mean, you and I are most likely covered under the provincial regulation here, but that's basically the gist of it. We will be talking mostly about the provincial regulations, just because it's very straightforward. If we talk about the federally regulated regulations, it's a little more complicated. So I think that's all we have to discuss about this topic today. But if there's anybody that has a question on this, I'm more than happy to field questions at this point.
Sounds good. Okay, thanks, brother.
Okay, so if there are no questions on this topic at this moment, we can discuss the next slide, which is wrongful dismissal, right? So what is wrongful dismissal? Wrongful dismissal occurs when, an employer terminates your employment while they're in breach of an employment contract or an employment standard, right? This includes situations where there's no proper notice or severance provided, or your determination basically violates any sort of statutory rights. So I'll give you an example. Let's just say if your employment agreement says that, you can only terminate, if your employment agreement says, yeah, we can terminate you for any reason at any point in time, guess what? That's illegal because the ESA, the Employment Standards Act, the legislation that governs employment relationships in Canada, says you cannot terminate anybody at any point in time and not pay them their severance, right? So this is what we call a with cause dismissal, where there is a cause, and then for cause you can not pay any sort of severance, you can withhold. But even then, the employment contract should be exactly what the ESA states. If it's beyond that, and again, 95% of contracts are beyond what the ESA states, and that's illegal. So that's considered a wrongful dismissal. Even if you're dismissed without cause, right? And your contract has an illegal with cause clause, the entire agreement is invalid. So in a nutshell, if they're relying on one clause and it happens to be the correct clause, legally valid, and lawyers find a illegal clause, one illegal clause in the entire agreement will make it void, unapplicable. So at that point in time, when it's not applicable, what we do is we sue the company and we say, hey, this is wrongful termination. You had no authority to terminate our client. You had no authority to terminate them under whatever pretense or guise that you used, right? And at that point in time, we use case law to determine how much you should be getting paid. So there's 3 different types of terminations in Canada, which happen under employment. One is the dismissal without cause. That could be, you're getting dismissed at any point in time for whatever reason, and the employer pays you. They pay you a sum of money. They pay you severance pay and what they call notice pay. Notice pay is basically how much notice do I need to give this person in order to terminate them. So usually it's 2 weeks of notice. So I need to give somebody 2 weeks of notice or payment of 2 weeks in order to get rid of them right away, right? So that's what we call the notice pay. And then there's severance pay. Severance pay is based on length of service, age, and your position in Ontario. And then we have dismissal with cause. Dismissal with cause basically is when they have a reason to fire you. Like you were negligent in your role, you were willfully disobedient, right? And it's a really high threshold in Ontario for an employer to prove that you were actually disobedient, right? I would say even if you were disobedient, a lot of employers don't like to go down this route of dismissing people with cause. What they will do is dismiss people without cause, right? But if they do dismiss people with cause, they have to prove it, and it's really hard to prove. So they'll just dismiss people without cause, even if there is a minor trivial issue. The next thing I want to discuss is what steps we can take to protect ourselves from being wrongfully dismissed, right? So first thing is document everything. At any point in time, you see that you are going to be, you were facing some sort of discrimination or some sort of constructive dismissal, which is, the employer is building a case against you to fire you, maybe making your job unworkable, right? Maybe taking your tasks away, maybe making it really tough for you to conduct yourself at work. That is called constructive dismissal. Anytime you see that there's something that is affecting your right to work properly, document everything. So emails, letters, communication that you may have. I journal on a daily basis. And I always encourage my clients that, hey, if you're going through any sort of workplace issues, you better start journaling. Journal journal every day. Journal the time. You might have had interactions with key employees inside the corporation. Just because fresh evidence is the best evidence, right? If you have notes on a daily basis, that's really admissible. That's very admissible in court, and judges love that stuff. And then in addition to that, once you're journaling, make sure you have a nice timeline of who, what, where, when, why. And then seek legal advice. It's very important because a lot of people are being, they will be wrongfully dismissed. They'll leave money on the table, or they'll face some sort of discrimination, and they won't do anything about it. But the thing is, you've sacrificed so much of your time, your effort, your patience, and your energy towards an employer, and for them to get rid of you and just pay you 2 weeks, it's not good. It's unethical. So that's why we have laws in place. That's why we have legal procedures in place to get more severance and more notice pay from employers. Now, the severance pay and notice pay, again, I did speak about it, and I think the next chart will be really helpful to help you understand the difference between severance and notice. Again, there's a famous case, it's called the Bardal case, that determined that the length of service is the length of severance pay is based on your length of service, your age, and your position. And there's a few other factors. So if you have an MBA, right, guess what? You're more qualified. It'll be harder for you to find a job. If you're a little older, it'll be harder for you to find a job as well. If you've had your career in one specific niche practice area, it'll be harder for you to find a job. And because it's harder for you to find a job, you warrant more severance pay. And right now, what we're going through on both sides of the border is that there's looming tariffs, and it has affected every single industry that's out there. And we're very busy at Thrive Law just because of these looming tariffs. Employers are calling us for advice. Employees are calling us for advice, and they're asking us, Saad, how do I protect myself? Because we've heard that there's been terminations. We've seen so many terminations in the past month. So even economic downturns and economic conditions can warrant more pay for the employees. It is very important for everybody to keep that in mind. So Understanding ESA minimums, the employment standard minimums for termination and severance. So if you've worked less than a year, then you get 1 week's of notice or 1 week's of notice pay just so the employer can get rid of you right away, right? And severance pay by law is not applicable at that point in time, right? But if the contract is illegal, then guess what? We're able to find it. We're able to get you more severance pay. If your years of service is 2 years, over 1 year, then you have 2 weeks worth of notice. And again, severance pay is not applicable. And then 2 weeks, all the way up to 5 years. So it just adds 1 year for every 1 year for every 1 week for every year served, right? So when you go up to 5 years, it goes up to 5 weeks, and then this is where severance pay kicks in. You can get up to 5 weeks of severance just because you are a tenured employee. And then once you go 8 plus, the minimum notice is about 8 weeks. And then your severance pay can go up to 26. Now, the severance, like I said, it is based on a bunch of factors. And if the employers are suggesting a figure, guess what? We can always review it to see, based on your age, based on your qualifications, whether people were reporting to you, whether you have, a niche practice area where you've been working. All these factors add up, and we can get you more than what the severance pay that the ESA guarantees. This is all based on the common law. All right, so I want to take a moment to ask if anyone's ever been through the unfortunate experience of going through, being terminated, and if you've received severance pay, if you negotiated it, how did you deal with it? If you guys want to take a opportunity to go ahead and provide your feedback in the chat, I would love so. I would love for you guys to do so, and then it gives us a better engagement of understanding of what you guys go through, and what the average employee is suffering through.
Jonathan, go ahead, sir.
Yeah, I'm curious. I'm on the south side of the border. And so in the US, there are many at-will employment states. And so, how does this, most of the call, a lot of the folks on the call are Canadians. I'm not one of the people who believes that that's going to be our 51st state. So, I think it's important to declare that these days. But like, how does that work in terms of at-will employment? Because what I've read, again, not an employment lawyer, it looks like it's pretty simple. Somebody just decides, hey, look, you're out. That they've got a lot of the law and the support on their side.
That's a great question. And for employees in the United States, again, I'm not an American lawyer, so I can't give you legal education on that. But from my understanding, because it is at will, right, there's universally applicable safeguards for everybody to look into. One is, before you sign an employment agreement, find out what your severance looks like. I understand there is at will termination in the United States. However, if you're able to negotiate a severance, be proactive about it, they have to stick to that. So now what's interesting is you can even in Canadian employment contracts, you can have your employment contract state, okay, I should be owed a minimum of 8 weeks, or it's similar to how the structure is that you see on our slides. It could be structured that way, and then you can also put in a bunch of factors in the termination clause and say, hey, look, if I get terminated at will, this is how much I should be owed, and we should have an open discussion, right? Certain factors should be considered in terms of how much severance I should be getting. I should be required this much minimum notice, and then this much severance pay based on how long I've been working there and what kind of roles I've been taking. And if I have received a promotion, what do I do then? Right? So, you can't really have a reactive response. I can't really advise on a reactive response unless there was a discrimination case or some sort of constructive dismissal case that was made against you. Then I think, you could, in the United States, you could defend your firing. However, if without the reactive stage, just be proactive, right? Every single employment agreement is open to negotiation. You do not have to go through what do you call it? You do not have to accept the terms that they offer, right? You are ultimately in demand for them, right? employees, as much as I like to say that employees are being interviewed, the employees are also interviewing the employer to see if they're a right fit. And especially if you're a highly qualified individual, right? You should always take that approach to see whether you have a right fit. And that just, it reflects in your bargaining power within the employment agreement. I hope that answers your question.
Yeah, no, and I appreciate all the other things you've said as far as, just, documenting everything that you can, because, in a situation where a friend of mine was recently terminated from a position, she had, she feels like she was targeted. And so, it feels like there's discrimination. She's hired an employment lawyer. She had a lawyer from a year before she was fired. And in the conversation of like the severance negotiations, like the company's attorneys said something about like, oh, you have an attorney? Well, yeah, like y'all have attorneys. I've got an attorney too. So what was beautiful about it was that she was sharing all of the documentation, supporting all of the things, everything you just said, Zayed. Document everything as much as possible. Make sure that you're keeping track of all these things. Basically getting, I think the lingo that the kids are saying right now is, bring the receipts, right? And so she's done that, and she's ready and prepared for it. And it looks like she'll be successful at her case because she has done all of the due diligence to help prepare her attorney. So I appreciate everything you said, because you're right. Like, we've got to all have jobs, right? And we shouldn't be abused in the process. And I'm glad there are laws out there, and I'm glad there are attorneys out there who are doing the work that you're doing. So I applaud you. Thank you.
Thank you. No, it means a lot. And in terms of attorneys being involved, right, throughout the whole process. So employment lawyers are some of the nicest lawyers that you will ever encounter on both sides. If it's an in-house attorney, then they're not so nice. But if you have, they'll usually hire an employment lawyer, and 95% of my matters don't even make it to court because we use alternative dispute resolution methods, and I don't take a very adversarial approach. I take a very professional approach. I know my law. I know what ground I stand on. And when I'm able to approach the other side and I say, hey, look, I have justified my position. Let's just resolve this as soon as possible. But at the same time, we're firm, and we send them a draft statement of claim or whatever legal court papers that we have. We send them a draft. So we let them know our finger is on the trigger, and we're just smiling at them at the same time. We're saying, hey, cooperate with us, right? We're not taking an adversarial approach because emotions get involved, right? And the great thing about, I guess not so great, but, employment law decisions are very faceless decisions, right? So if, employees will come to me and say, Saad, I've been working with this company for 8 years. I've given them my blood, sweat, and tears. I've given them everything. I've sacrificed everything. And they just let me go, without, over a Zoom call. Right? Yeah, it's disrespectful. Yeah, you would feel very, disrespected in that scenario. But it's a very faceless decision. Now, if you start handling these matters yourself, you have emotions involved because you had been invested in this corporation and your work had been invested in this corporation for X amount of years. So that's where lawyers, when you hire attorneys, we make it faceless for you as well. Right? So we don't cite any emotions. We don't cite any law in our documentation. I mean, we cite law, but we don't cite any emotions or feelings, right? It is a very faceless approach for us to match them. But when we get onto a conversation with the opposing counsel, it is very much a friendly conversation most of the time. I've had a few situations where, again, 5% of my matters where it's gotten ugly and we've had to go to court. And when we do go to court, there's a mandatory mediation stage where these matters just get resolved, because a mediator will always vouch for the employee every single time, unless the employee had done something outrageously, unacceptable.
So Brother Saad, there is some folks who raise their hand to ask questions. Do you want to do this now, or do you want to just run with the slides and then cover all Q&A at the end?
Let's try to cover the Q&A at the end because there's a few more important topics, but I think let's just take one more question, and I think we could leave the rest for the end.
Sounds good. Okay, Saad, if you want to unmute and ask your question, please. We cannot hear you, Saad, if you're speaking. Okay, maybe you have some audio issues. Okay, maybe let's cover this at the end, Saad, if you don't mind,
Sure.
just for the sake of time.
Absolutely.
And Brother Mahmoud and Samer, can we just ask those questions at the end, if you don't mind?
Ahmed, it was just the at will concept. I didn't get it. Like, is it that's different from resignation?
So fire at will in the United States is basically they can fire you for any reason at any point in time without giving you any sort of pay. Right? Here in Canada, they can only fire you for two separate reasons, with cause or without cause. Right? And if they fire you without cause, then they have to pay you money. Right? But everything in the United States is fire at will without paying any sort of minimums, severance pay, or anything like that, unless your employment agreement says otherwise. Does that clarify your question?
Yeah.
Okay, awesome. All right, guys. So what I'm going to do is I'm going to proceed with the presentation, and then let's see how things go, and then we can answer more questions at the end. Okay. So the next topic I want to quickly discuss is the human rights, workplace harassment and discrimination, which is, it is a very huge area of law, and it falls under human rights. Nearly 40% of Canadians experience workplace harassment at some point in their careers, and which is a lot because harassment comes in different forms, right? There's verbal abuse, there's exclusion, sexual harassment, and barriers to equality in employment. So if you see a certain type of class of people, maybe a certain religion or maybe a certain gender or maybe a certain type of ethnicity being promoted within the company, or maybe they have affiliations to a club outside of the organization that has allowed them to go ahead and surpass you and get promotions beyond which you should get otherwise. That is also discrimination, right? So the legislation in Canada, we have the Human Rights Code and the Occupational Health and Safety Act. It provides provisions for workplace harassment. I'll give you an example of a case that we just settled about a week ago. A client of ours, he happened to be of South Asian descent. And he had a manager that kept on coming up to him, sniffing him for his body odor. And he made very derogatory remarks about his accent. And, he made very demeaning gestures, mocking the employee. Thank God our client had a lot of evidence and a lot of witnesses. And we prepared our legal materials, our legal documents, our statement of claim, and we prepared a demand letter and we sent it out. And we listed it out as to how this is, it was an all-in-one type of case where we saw all sorts of discrimination, including bullying and harassment of a visible minority. And we were able to get $52,000 for our client. And this was, again, considered constructive dismissal because the employment environment had made it tough for my client to go ahead and pursue his work duties, peacefully. That is a case of constructive dismissal. So this is a type of situation that we've dealt with. Again, even microaggressions are something that a lot of employers are talking about these days. Small little things that may build up over time, patterns, and this is what you have to go ahead and document, right? At any point in time, you see something that may be affecting your employment currently or your future growth is something that you always have to document. Now, what steps can we possibly take in order to protect ourselves? Make a complaint to HR, right? You can also file a complaint with the the Human Rights Commission here in Ontario and other provinces. And then, these are steps that you can take and to keep HR apprised of any sort of steps that may be used against you. And also, I encourage everybody to send yourself a blind copy of any sort of emails that you might be sending internally to justify your position and why you need to protect yourself. And so that is very, very important because the day that you're terminated, they'll remove all access from you accessing any sort of emails that you can have as evidence against the corporation. It's very standard practice. So I encourage everybody to take those steps. We can also, I mean, if you're looking at the Human Rights Tribunal, you can always review their tribunal-specific guides on how to complete the forms. If you are what do you call it, filing a complaint, you don't necessarily need to be fired in order to make a complaint. You can be working at a place, make a complaint, and then still continue to work. What are they going to do then? If they fire you for making a complaint, guess what? That's called reprisal for asserting your rights, and they fire you. That usually that warrants at least $15,000 to $20,000 in damages alone, despite all the other factors. I just wanted to share one case with you where there is where the employer mishandled a complaint, and they weren't holding anybody accountable for sexual harassment within the corporation, and it impacted the employees' well-being. This particular case, it happened in Northern Canada. There's a very well-reported case as well, and what the employee got out of it was $209,000 tax-free because it's legal damages, and not as employment income. And this just shows you how much the law, respects our dignity and our safety at the workplace, and how much it's overlooked by employers and employees alike. So in Canada, you can make a complaint in two separate ways. You can make a complaint to the CHRC, which is the Canada Human Rights Commission, and then there's provincial provincial tribunals as well that you can go ahead and file complaints to. This is basically an overview of how fast or how slow they'll respond to your matters. Now, the decision issuance, you'll see at the very bottom left-hand corner, varies by the complexity of the case. However, in our experience, it's usually less than 4 months that these decisions get settled with. Now, the difference between the CHRC and the provincial tribunals is that, again, at the beginning of our discussion, we talked about how there's federally regulated employees and then there's provincially regulated employees. The federally regulated employees, they will be governed by the CHRC. And then the provincial would be they would be able to apply to the provincial tribunal. All right. Now, I did mention that I had some good news for tech workers, and that is employee misclassification. And this actually applies across the board. It applies to both Canadian workers and American workers. There is a difference between employees versus an independent contractor. Now, what happens is when you're an employee, you are dependent on your employer for instructions. You're dependent on your employer for time. You're dependent on your employer for equipment, and they supervise your work closely. You're an employee. However, if you have been hired as an independent contractor, you set your own hours, you have your own equipment, and you supervise your own work very closely yourself. And that's why you would be treated as a contractor. Now, I'm going to pose a question. Let's just say there's a contractor, right, who has his own equipment. Sorry, let's just say there's a contractor, right? You've signed an agreement as a contractor and employer. The employer is setting your hours. Your employer is providing you the equipment, and they supervise your work, and they treat you like an employee. Are you still a contractor? Any guesses?
They are considering you as a contractor only in the type of dismissal. That's it. Because they don't want to connect with you an underemployment employer contract, so they don't face this whatever you mentioned before, right? So when you are a contractor, they can say you goodbye at any time, but they are paying you the benefits, they give you the equipment, they give you everything. In that case, they have no commitment with you.
Well, that's right. But here's the thing. Imagine if you're a contractor and they set your hours and they set your equipment and they're monitoring you as a contractor, as like they would have done it as an employee. even in that situation, you don't have an employment agreement, but you have a contract with them as a contractor, you would be considered as an employee. Because if it walks like a duck, if it quacks like a duck, it's probably a duck, right? And despite it being you being a contractor, you would be considered an employee under the common law. So it gives you a lot of protection. So you can actually get more money as an independent contractor because, as an independent contractor, you're filing your own taxes, you're filing your own deductions, right? And, in the tech industry, it is super lucrative, very lucrative to become a contractor. Why? Because you can end up, you can establish and incorporate your own business, your own corporation, and through the corporation, you can provide contractual services and make close to 30 to 40% more than you would have as an employee and write off all your business expenses. Now, the downside is you don't have that sort of protection that an employment agreement would have in terms of severance and in terms of termination pay. However, we always advise our client to negotiate that ahead of time. So if there was some sort of termination within, let's just say on a milestone basis, within the 3 months, if this contract becomes terminated, then there's a termination fee owed to the contractor for X amount. If it's termination after 6 months, another amount. Termination after a year, another amount, right? And then this contract would renew on an annual basis based on mutual agreement of the parties. So that's like the ideal way to structure your relationship with an employer. But if you want the employment benefits of having the employer set all your work and you just want to go to work and do your thing, come back home, then focus on your life, then being an employee is probably better for everybody. But there's always these misclassifications, and obviously, like I said, and even an independent contractor could be considered as an employee. And in that situation, there's money on the table for you to go ahead and take, even though your agreement doesn't say it. Even though if your agreement doesn't say that you're an employee, you'd still get the ESA minimums, you still get severance. So it's like having the best of both worlds, but you need to make sure you're very, very careful with how you structure this.
So Saad, does that apply for the multi-tier independent contractor where the contractor is working for a recruiter and the recruiter is sending them to the client, but the client is the one giving them, for example, the client laptop, determining everything, taking all the decision?
That's a very, very good question. And it's actually and I'm sure I could tell you're in the tech industry because the tech workers are exposed to this sort of relationship, right? And what happens is, now, every corporation will have a headcount limitation. They'll say, we can have this many employees, 20 employees, right? Beyond the 20 employees, what they do is exactly what you described, a scenario where they'll get what we call leased workers. They're going to be leasing workers. So the employment agency or the HR company will hire the employee as a full-time employee, as an employee, but then they'll send the employee off to a corporation to work on a task, right? In this scenario, who would we sue? We would actually sue both companies, right? For termination, if there's any sort of termination issues. But who is the true employer? The true employer or there's the true employer and then there's the employer on record. The employer on record would be the HR company that's hired you. The true employer is actually the company that you're working for, right? They try to do this to minimize any sort of liability, to say, hey, look, if there's any sort of liability that happens on the client who you're working for and, they mishandle you, they have any sort of discrimination, the client can say, hey, you can't sue us, right? Because we're not your employer. Go sue the HR company. But again, they're the true employer. The client is the true employer, right? So you would sue both in this scenario. And we have had so much success in terms of going after employees who have had, their rights trampled on in those scenarios. Because, it's a very simple case for us to say, hey, look, one of you have to pay up. Who's it going to be, right? Do both of you want to go ahead and face legal fees, or do one of you want to pony up and just resolve this matter easily? And it's usually, these matters get resolved very, very easily.
Brother Saad, we have like 5 minutes before the end, and maybe we can stay a little bit longer. We
Sure.
normally stop, on top of the hour just to take a group selfie. So I'll let you maybe run with whatever you can in the next 5 minutes. Then we can stay for Q&A after the selfie.
Absolutely. So I'm going to quickly get over I'm gonna zoom through a few points. Gig workers, freelancers, Uber drivers. If you're working as a gig worker in the gig economy, guess what? There's Canadian laws that say that you're actually an employee. The employers will try to deny this as much as possible, but there's ways to get around this. It's very easy. As long as you have legal representation, we're able to navigate those issues very easily and get you treated as an employee and even get you back pay for a lot of different situations. Again, here's a quick overview of the different aspects of the legal protections and the misclassification risks between employees and contractors, right? So the tax responsibility would be the employer's duty, but if you're a contractor, you do it yourself, right? Benefits you'll be entitled to, but you won't be entitled to benefits as a contractor. Control, you would have control. The employer would have all the control over what you do, whereas the employer and the contractor would have control over their own hours, their own tools, and the methods of their work. And then, legal protections, the ESA and all the laws that we talked about earlier, they're actually protecting employees. But what protects the contractor is just basically contract law or whatever the terms are in the contract. And then the work relationship is, for an employee is long term. It's a long term and it's integral to the business, and it's indefinite. Whereas, being a contractor, it is short term, it is more project based, but it is finite and it is definite. So 1 year term, 2 year term, and then there's different ways to structure it. Here's where the law gets very interesting between America and Canada. We have job protected leaves such as parental leave, medical leave, and bereavement leave. There is actually very considerate laws here about leave, where both parents can take leave. A husband can take leave, a wife can take leave when they have, when they're welcoming. The father and the mother can both take leave when they're welcoming a child. You can actually even take leave for adopting a child in Canada. So adoptive parents can get up to 13 weeks of leave. Now, what a protected leave means is that while you're on a leave, they cannot terminate your job, right? Or what you do on a leave, they cannot terminate you for that leave. And then I'm trying to zoom past this because I want to make sure that we get as much as we can, and then we can take a Q&A session at the end. But we don't have much to go through beyond this. The workplace accommodation. So every single employer in Canada has the obligation of making sure that your workplace is you're able to do your workplace, that they can make reasonable adjustments for your disability, for your family, and for your life conditions, right? As long as it's not causing undue hardship on the corporation, meaning that if they're going to be accommodating for you, they have to accommodate for everybody else. And, it's going to cost them, maybe $5 million in adjustments just to make, an employee who's being paid $60,000 or maybe $70,000. They're not going to do that. And then they'd rather just, settle with you, pay you a little bit of money, and end the employment relationships at that point in time. But most employers, if they see a pattern of what they can accommodate, they will try to do so. Next, I want to quickly just go into a topic that of the upcoming updates in Canadian law, and in the American regime will also see similar laws coming into place, specifically around the AI issue. So there's new parental leave and adoptive and surrogate parents expanded leave. So it went from 13 weeks to up to 16 weeks. And then you have to have at least you had to have at least 4 months of continued employment to qualify. And then what's interesting is there's also workplace harassment reforms, right? These workplace harassment reforms extend to now emails, text messages, social media, and stuff that happens at home, right? Because you're working from home these days. Most people are. And so, even emails, if your employer is contacting you after work when they shouldn't be, outside of work hours, that's considered harassment. But not every single situation. Again, you have to run this by a legal professional to find out whether or not this is considered harassment. Finally, I want to quickly go over the AI updates that we're going to have in Canada. So there has to be, there's new legislation that's effective on these dates that we have on the right-hand side. But AI, if there's any sort of AI involvement in hiring, there has to be transparency, right? Because AI could be used to weed out, a lot of potential candidates just because of where they went to school, what kind of experience they've had. They can even pick up, like words that are used. Maybe if someone doesn't have this, a strong literacy rate, your education can be used as a discrimination tool against you. So there are a few different legislations that are going to be in place. And then sooner or later, they're going to be also legislation in place that lets you know whether or not AI will be a part of the tools that you'll be using at work. And I think that's very important for employers to disclose that, and very important for employees to know that, because you might get fired for using AI when your employer doesn't allow you to. So I know we're just at 12. So I think, Ahmed, you wanted to take the group selfie. Once we do the group selfie, I'm more than happy to engage in a question and answer session with our community.
Awesome. Yeah. If you don't mind, maybe you can stop sharing, Brother Saad, and we'll take the group selfie, and then we can again go through the Q&A with everybody.
Absolutely.
So guys, this is your chance to shine and become a celebrity for this call. So I'll do the together mood. So if anyone else want to join the selfie, please join it now before it becomes too late to become a celebrity. So I'll give it maybe a few seconds here, and I'll say 1, 2, 3, and smile. Okay. So 1, 2, 3, and smile. Awesome. Thank you so much, Brother Saad, for the great wisdom that you're sharing today, and thank you everybody for joining. We'll stay around for questions. So I'll stop the together mood now, and guys, go ahead and raise your hand and ask your questions.
Before you guys go, I just want to quickly emphasize one thing, right? Before the